Welcome to an oral argument session of the 5th District Court of Appeal. We have on the docket today the case of Marisol Rosa versus Safe Point Insurance Company, and that case number is 21-3005. I'm Judge Nardella. I'm joined today by Judge Sasso and Judge Wozniak. Our oral argument today is being live streamed, and it will also be recorded on the YouTube website, so please keep that in mind. Mr. Nation, as the appellant, how many minutes would you like to reserve?
5 will be fine, Judge. Thank you.
We'll do that. With that, counsel, you may begin.
All right. Thank you. And good morning, everybody. First of all, I recognize what I'm asking this court to do is disagree with the 4th, the sister court, on this issue of active nature. What the 4th did in this case is really unprecedented in the history of insurance policy interpretation. I've never seen a case where they reject Couch, reject blacks, and then go on and don't define a phrase, active nature, even though 8 times they say they have to interpret that phrase, and instead use a dictionary to define the word act, separately define the word nature, put it back together, and then come up with this sentence. Using these definitions, act, and they put it in quotes, and nature, they put nature in quotes, can be reasonably interpreted to define the everyday meaning of an act of nature as the doing of the inherent character of a thing. There are almost...
Going back a couple paragraphs in Dodge,
yes.
Doesn't the 4th DCA cite a couple cases, albeit not from Florida, where it does analyze active nature, quote unquote, as a phrase? It says, we agree with People's Trust that the ordinary meaning of the term active nature is something that naturally occurs, and then cites 2 cases and then gets into splitting up the words.
They don't define, that was the accumulation of ice and snow. That's an event. That's an external force. And that's what they're talking about there. The other is they have a true tree root case.
And how are those issues different, or those events different than rust or corrosion that we have here?
Okay, so, and I will and I have a chart, I think, in my initial brief. When you have, first of all, this policy specifically states that they will cover water damage from a plumbing system if it's caused by wear, tear, deterioration, and corrosion. So they know how to say that. They specifically grant coverage for that. Then we look at what is an act of nature. What is wear, tear, deterioration, and corrosion? It's certain to occur. It's occurring in this office right now. It's occurring in that courtroom. And it's occurring in all of our houses right now. It's certain to occur. It occurs over a long period of time. And it is a natural process. They can't stop it. Now, an act of nature, as defined by Blacks and Couch, is something that occurs at a moment in time. Hurricanes, tornadoes, that type of thing, and it is not certain to occur at everybody's structure. And it occurs in a moment in time. And we couple that with the entire phrase, the modifier, caused by or resulting from a human or animal force or any act of nature. So we start with human.
Equating act of nature and act of God. I did notice in the policy that act of nature and act of God are both used. I think act of God about 5 times, act of nature 3 times. It may be the opposite of that.
Yeah.
Do we take that into account, that both of the terms are used? Should they be treated differently, interpreted?
So they shouldn't be treated differently, and Black's Law Dictionary says they're synonymous. And and if we think about this, some people are hesitant to use the word God. And now we have turned to act of nature. And that's why Black says it's the same thing. And you have to look, those things were written by different people at different times. That endorsement, it was an endorsement that was added to the policy. That's the WDX, water damage exclusion, written at a different time. If you look at the dates at the bottom, they're going to be different. Different people are going to use those words because, one, they're uncomfortable using the word God, and two, they mean the same thing.
Counsel,
Now, yes.
no, I'm sorry. I want you to finish. Go ahead.
Oh, and in addition, I think that hurts them. Because when I said, you look at what the fourth did, they said our definition, which we created, is a reasonable definition. And then they seized on it. They said, all right, theirs is a reasonable. And so they said, therefore, people's trust in that case wins. The insurance company wins. That's the opposite of the law. Nobody can say that our definition is an unreasonable definition. It's clearly a reasonable one. When I said it was unprecedented, what I meant was 5 trial courts from across the state post-Dodge specifically wrote, I read it, I disagree with it. That is, I've never seen that. Unprecedented. 22 courts prior to Dodge said wear and tear is not an act of nature. Unprecedented. I got involved in Dodge. All those other, yes, I'm sorry.
Yeah, just going back to the act of God, act of nature. I'm struggling to see how construing them the same way is consistent with our obligation to construe the policy as a whole. And there's other contextual clues here too. First, act of God in the policy is capitalized. And our phrase here is any act of nature as opposed to an act of nature. Help me see why those additional contextual clues don't suggest there's a difference in meaning between act of God capitalized and any act of nature following human forces and natural forces or animal forces.
Let's not lose sight of the word act and force. So force, human force is maybe driving a nail. That's an event. A animal force is maybe a raccoon chewing through a line. That's an event. And the words are known by the company they keep. And then we have any act of nature. An act of nature, easily, tornado, earthquake, volcano.
Why can't it be natural force or a naturally occurring event? Natural
processes, wear and tear is a natural process. Couple reasons. One is if they meant for that to be included in there, they knew how to say it. They have a specific grant of coverage in their perils insured against that says, we cover water damage from the resident's premises plumbing system caused by wear and tear. So they knew how to say it. And then they try to hide that elephant. The elephant is the grant of coverage in the mouse hole of act of nature. That's not the way we would interpret the policy, but at least leading us to the conclusion there's more than one reasonable interpretation of act of nature, in which case you'd have to choose the one in favor of the insured. Same thing we did.
So let me go to that too, because Florida, the cases I will agree are imprecise. But I think Justice Polson in his dissent in Washington National Insurance does a survey that says if there is two truly reasonable, in other words, after we have construed the policy as a whole, if there is a true ambiguity in that place, the construction against the drafter rule is still a last resort. We would go first to extrinsic evidence of intent. Why do you think it's appropriate to skip that step here? And if we conclude there's two reasonable meanings, skip straight over extrinsic evidence of intent and go straight to construction against the drafter?
You do go straight to it because of the unique context of the insurance policy. I've dealt with that issue before. I think that case was not an insurance case. And there's an exception for those involving insurance policies, which are always, you don't look at extrinsic evidence. It's always interpreted against the insured. And Judges Nardella and Wozniak just held that recently in my case, Vasquez, on that exact ground. So I don't think that's an insurance case.
It was an insurance case, and that's just so your argument for why should we skip over that step is there's 50 CA cases saying that we go straight to construction against the drafter if there's an ambiguity.
Not just the fifth, it's all over. I've had that raised in a trial court before one time where they said we got to go to extrinsic evidence, which would mean you got to put on my client to say, what did you mean? What did you intend? And then put on the corporate rep from the, you don't do that in the insurance context. And there are a bunch of cases that say that. I didn't brief that, but you'll find those.
Counsel, I want to follow up on Judge Sasso's question and kind of along the lines of the argument you were making earlier. It rings true to me when you argue that act of nature and act of God are synonymous. That's how I was trained as a lawyer. But looking at this from a layperson, I have some questions about, as Judge Sasso was talking about, the clues which you see in this policy as to whether they are supposed to mean the same thing. And to me, one of those clues, as she referenced, was any versus and. I have been trained to always hear an act of God, an act of nature. Our policy has any, and out of curiosity, I Googled any act of nature, any act of God in Westlaw. There were not a lot of returns for that phrase. And as she also notes, there's a capital A, which to me singles for an act of God, that's a phrase. It means something. Those words can't be separated. But you don't see that with act of nature. Can you talk about those two clues, why we should discard them?
Yes. I just think, I don't know why it's capitalized, because in a policy, capitalization means it's defined and it's not defined. I think that's just how people have written that over the years, and they capitalize those letters. The fourth in Dodge said 8 times it's a phrase, and it is a phrase because none of us use that term outside of insurance policies. I don't even think we use act of nature in regular contracts. It's only seen in insurance policies.
I was going to ask about that. Have you done any research for usage, for common usage of the phrase any act of nature? Or is it your argument that it is just a phrase? It has a legal meaning. We were all trained what that meaning was in law school.
It is a legal phrase. The fourth said it 8 times, the phrase. And when they didn't say it was a phrase, they said the term. And then they make a point of saying, well, we're not going to define it. We're going to define the word act separately. We're going to define the word nature. And then they put those two together. That is not how you would interpret an insurance policy. And if you did, you would have to come to the conclusion that our interpretation is a reasonable interpretation. I don't know how they can say our interpretation is not a reasonable interpretation when we see a distinction between wear and tear over time versus an act of nature. Or they see it's going to happen in everybody's house, wear and tear, whereas an act of nature, tornado, might happen to somebody's house. Doesn't happen to most. There's a clear distinction between those. Couch makes that distinction and says, we're going to distinguish between those two. In the same day, the fourth issued another opinion in Triff, different panel, and that panel turned around and said, you have to use blacks and couch to define the phrase false statement. And that is the way it's always been done. This is unique. And I don't know that anybody here has ever seen 5 trial court judges after an appellate opinion say, I disagree on this, not just the interpretation, but the way it was done and the result. And then we have 22 trial court orders across the state before. It has to be a reasonable interpretation. And if they meant to exclude it, they knew how to say it because there's a specific grant of coverage for that in this policy. I don't know how much time.
You have 7 minutes.
I don't have a lot more. There are no questions right now. I will say this. If they mention Panettiere came out after Dodge, that case could not distinguish itself. The panel in that case was not allowed to disagree with Dodge because it was a different term of the DCA. And they're not allowed to turn around and say, oh, we disagree and we're going to have conflict with the prior decision. If it had been the same term, they could have done that, but it was a separate term. All right. Thank you all.
Good morning. Patrick Chidneys for Safe Point Insurance Company. May it please the court. I think we agree on the provisions that control. The question today is whether the decision from Dodge, and Judge Wozniak, you touched on this definition, that an act of nature means something that naturally occurs, or are we going to do, as Appellant's counsel suggests, and take Black's Law's definition of act of God, a one-time extraordinary unforeseeable event, and substitute that in for act of nature. And I think the easiest way to explain why the Dodge decision is correct, particularly in this case, given the contextual clues, I'm going to start narrow and move out. So I'll begin with just the phrase act of nature, any act of nature, which is important. And the standard here today, Judge Nardella, is the ordinary insured, what an ordinary person would take from this policy reading it, not necessarily terms of legal art and certainly not legal definitions of different terms.
Counsel, I want to hear what you have to say. I really do. But before you jump in, do you have any examples when we talk about the ordinary person? And I agree with you that that's our standard. Do you have any examples from literature, magazines, newspapers, movies, anywhere that uses the phrase act of nature to mean a natural process, hence showing that an ordinary person would use the language that way?
Sure. Aside, are you talking aside from the case law, or can I cite to some cases?
Absolutely. Aside from the case law, I'm looking for any evidence that you have that that's how the phrase is used by natural people, by a person, by an ordinary person untrained in the law.
I think that you have to look at it like if I were to say this to a human being. I mean, we all have our sort of intuitive response to that. I don't think anybody's cited to any secondary sources, and I certainly didn't go outside the record, but there are plenty of cases interpreting that precise phrase, actually interpreting the precise phrase any act of nature. And one of the Dodge decision cites the one, that's the Erie decision from the Supreme Court of West Virginia. And in that case, the court said that act of nature means anything that naturally occurs. That's what we all think it means. That's consistent with Dodge's first definition, which cites the two other cases. That's the Holben case, the ice case, and the coil case, which is a tree root. Ice, we expect naturally to freeze. Tree roots, they naturally grow. Now, the amicus cites to another state Supreme Court case that was pretty recent called the Bibeau decision, B-I-B-E-A-U. That was the Maine Supreme Court. And actually, I think that one is fairly analogous. And they considered a very similar argument and rejected it. There was a pipe leak in that case that leaked down through the soil. And over the course of about a decade, it interacted with the soil, causing some shifting, causing some cracks. The insured in that case made almost the same argument as here, that the only time this is excluded is when the force of nature is something like an earthquake or a volcano. And the court looked to the language, which was specifically any act of nature, and held that the common sense meaning of that, what an ordinary insured would interpret any act of nature to mean, is not just the big ones. It includes anything that nature does, anything that naturally occurs. And that's the ultimate decision that the Dodge court reached. It did not take the technical legal definition of a completely different phrase and then sub it in for any act of nature, because an ordinary person wouldn't think that.
Even if we agree that a technical legal meaning shouldn't be applied and we're looking at it through the lens of ordinary language, doesn't that leave open the option, though, of this being an idiom, just as individuals use idioms in their normal speech?
I think when you look at the phrase, you need to think of it as if you were just reading this phrase, any act of nature. And I think that taken in its common sense, as every one of those cases has held, the general interpretation of an act of nature is something that naturally occurs. That's what an ordinary person, if I just look at that single phrase, any act of nature is something that naturally occurs. Now, that's in this case extremely bolstered, that sort of isolated view of this. And bear in mind, that's what's counsel is proposing, is we look at this thing in a vacuum. If we start looking out from that, the contextual clues in this case are extremely telling and significant. The first one is, well, okay, act of nature, what comes right before it? Acts of forces of human or animal, any human or animal caused by or resulting from human or animal forces, or any act of nature. Now, note this doesn't require any damage actually to the pipe or anything like that. But the first point I want to make is those first two terms, human animal. It doesn't say catastrophic, overwhelming human animal forces. It just says any force of human or animal. And I'll point out the argument that counsel made in the trial court, you referred to for animals, raccoons chewing through pipes. Now, when I think of raccoons, I don't think of overwhelming, powerful forces. If the first two terms—
What is your response to the argument that force suggests a one-time event as opposed to a process, and that we should read act in the same manner, force, act?
It actually cuts the other way. So it doesn't say force of nature. And this is interesting because this is brought up in the citation to Couch that's contained in the initial brief, section 153:3, talks about the difference between forces of nature and natural processes. Now, I'll note that Couch article says nothing about act of nature, so it's completely impertinent to analyzing this term. But what it defines a force of nature as, there is sort of a term of art. I mean, I remember when when I was a kid, teachers would refer to my sibling and I as forces of nature. I think if they had put force of nature, it would be more arguable that it's some type of singular event, but they didn't. They said any act of nature. It's not a force. Now, those two preceding forces of animal and man, it's hard to envision that being equivalent to something like a hurricane. And that's borne out by counsel's argument in the trial court that an act of nature of an animal would include a raccoon. But we also know from this context, if you look at that, once you look at that clause, any human or animal forces, any act of nature, it's meant to be a catch-all. And so where does this come from? Counsel was arguing, why didn't we say corrosion, wear and tear in there? That we knew how to do that in the base of the policy. Why didn't we do it here? Well, the answer is lawyers. Ironically, this was intended to reduce litigation because the typical fight in a first party case is, well, what caused it? Was this because the roof wore out, or is it because there's a windstorm? This provision is meant to capture every possible actor, human, animal, nature. And this is actually also in Couch, but there's a couple of sort of famous examples of that. If I drive a nail through a pipe and 10 years from now the pipe corrodes, was it human or was it from corrosion? And that can matter under the exclusions in a policy. What this term was meant to do was to reduce that uncertainty, to create a catch-all provision. And that's apparent from reading this phrase in isolation. Now the final.
Yeah, do you agree though that if we accept that as, you know, the intent, both the intent and the outcome of this language, that basically nullifies the exception in C6? Except we cover loss resulting from accidental discharge.
Yeah, so the exception in C6 on the base of the policy, is that what you're referring to?
Yes.
Yeah, so that it begins, it's the prefatory language is unless otherwise excluded, and this water damage exclusion endorsement would apply.
Yeah, it says we will insure property. We do not insure for wear or tear, except we cover loss resulting from an accidental discharge or overflow of water, steam within and then it says plumbing in the residence.
Yeah, the prefatory language of that says that unless otherwise excluded, and that's why we're arguing about the water damage exclusion endorsement. It's so at the beginning, right after exception to C6, unless the loss is otherwise excluded. That just means.
So you would agree though that kind of creates some superfluous language there.
No, the exclusion needs to exist. So the water damage exclusion endorsement is the operative exclusion. So you need to, when you look at that language, unless otherwise excluded, you got to go through the policy and see, is there some other exclusion that would independently bar the cost of tear out, which is what they're after. That is the water damage exclusion endorsement. So I don't think it renders anything superfluous. It's just, it operates consistently with that preface, which leaves room. Okay, there's another exclusion that acts here. That's what this tear out is not applicable. And I think we basically agree on that analysis.
Can you address the term accidental, which I see in the exception to C6, and then I also see accidental or intentional under 3D in the water damage exclusion endorsement, which I did not notice in the Dodge case. It looked like the Dodge case did not have the accidental or intentional language. It just started right with discharge. Is that a difference that makes a difference here?
I don't think it matters in terms of the fact that the water damage exclusion endorsement bars tear out in both cases. There may be other acts that would be excluded outside of the water damage exclusion endorsement, but I think the first point is an interesting question. The act is an accidental discharge. We make a point in the brief that this case does not involve an accidental discharge, and I'm not saying that as an advocate. I'm saying that by taking the appellant's statements as true. The argument they've raised to get out of this being an act of God is it's not an act of God. It's not some overwhelming event. This is certain to occur. It's definitely going to happen. The evidence in this case is consistent with that. This is a 65-year-old original cast iron plumbing system. If the failure of that system is no longer fortuitous, it's no longer accidental, the definition being unexpected or unintended. If you take their arguments as true, it's not unexpected or unintended. In fact, it's fully expected, happens everywhere. As counsel just said, it's happening right now, it's certain to occur. Those aren't the kind of things that insurance is meant to cover. We cite to a concurrence from then Judge, now Justice Lawson in the Narauchi decision, where he explains what fortuity means in the context of insurance. And it is not meant to cover things like the expected failure of a pipe after 65 years. That's just not what insurance is intended to do. So accidental, that term accidental operates within the tear out provision to basically limit the types of things that coverage can be provided for. Now, I don't believe the policy language in the Dodge case had that sort of accidental in there, but it still would apply. And the law still has to be fortuitous. And in this case, by the admissions, if you take those as true, it's not. Now, that's not primary to the interpretation. And the final point I want to make on the interpretation and policy context, which I still have yet to hear a solid answer for, and Judge Sasso hit on this, is act of God is elsewhere in this policy. The court has to construe the policy consistently. The only explanation I heard was that maybe drafters became uncomfortable using the term God.
I think the argument was that it's an exclusion. It's, drafted at different times by different people. So what's your response to that argument? First of all, how do we reach that conclusion? And is that consistent with our obligation to construe the policy as a whole?
Right. I think there is no evidence that this was drafted by one set of drafters who disliked the word God and one set of drafters who didn't. The court needs to construe the policy as a whole. And you read this thing as a whole, we have yet to hear an explanation for how act of nature can be subbed out for act of God when the drafters chose act of God in other contexts. And in those contexts, it actually makes sense. So you see it in the non-renewal and the cancellation provisions. And they say, look, we won't non-renew you if your claim is because of an act of God. Well, that's important, right? It's, if there's a hurricane or something, your policy is not going to be non-renewed for that. Then they separately use any act of nature, which is a broader term. Especially in the context, but certainly the court, what the definitions of how broad act of nature are, the court under this policy can't realistically substitute a term that appears elsewhere in the policy. The meaningful variation doctrine says that terms in a contract mean different things. I don't think that's overly controversial.
What is your response to the argument that there's two reasonable interpretations here? One is an event and a kind of a single occurring event. One is a natural process. And because of these, 22 circuit judges that predated the 4th DCA's opinion and then 5 after, that it's ambiguous. There's two reasonable meanings and it should be construed against the drafter.
Sure. So the first step, of course, is it a reasonable interpretation? And as we've been talking about, if you look at Dodge, if you look at Holden, if you look at Coyle, the West Virginia Supreme Court in Erie, and the Bebo decision, it's not a reasonable interpretation. And the reason for that is it's overly restrictive in isolation. I'm talking about that term in isolation. So a broad term, a term that's broad, is not intrinsically ambiguous. So something can be broad, especially where it's intended to be broad, any force of man or animal. We have a raccoon example. It can be a broad range of things, but it's not ambiguous just because you can come up with different examples that fall within that term. That is confirmed in this case by context within the policy. As to the decisions, the 22 differing decisions, I don't know how many of those entered orders like in this case. If you look at the record in this case, counsel went in and said, I have to lose because of Dodge, but I'm going to make a big, I think it called it a heavier ask, and said, I want you to enter an order that I have, that was entered in a different case, so I can take this up. I don't know how many of those cases, and the orders look very similar, have orders drafted by counsel where they presented the same arguments and they convinced a trial judge. But what I do know is that a conflict among the trial, first of all, every appellate decision that looked at act of nature construes it ordinarily. No appellate decision has found an ambiguity. And if you look at that Erie case from the West Virginia Supreme Court cited in Dodge, that court said they had unearthed, this is in 2017, they had unearthed no precedent finding this phrase ambiguous. So, okay, do we have trial court decisions that conflict? The existence of conflicting trial court decisions, certainly there's no conflict among appellate decisions, but we talked about that in our brief in a Supreme Court decision or Florida Orthopedic, where there was the 4th DCA decided a case and said there were dozens of trial courts split across the state about this question of policy interpretation, called it a sharp divide, and said, look, that doesn't create a presumption, which is an important point here, but how can we overlook that all these judges found this policy ambiguous? Supreme Court quashes that decision and says the court has to look at the policy as ambiguous. Are there truly different reasonable interpretations given what we've talked about here? Rust is a naturally occurring act. So that at the end of the day is, what is the reasonable interpretation? Is it confined to acts of God, setting aside the fact that that appears elsewhere in the policy? Or is it a broader range of events that could include acts of God if they become severe enough? I think that is how any ordinary person would view it. The question at the end of the day here is, if this corrosion were not an act of nature, what is it? What happens? The phrase act of nature is, in this case, is part of a broad catch-all meant to cover man, animal, nature. Natural oxidation, it's equivalent. It's the same as a tree root growing, ice freezing, these commonly understood acts of nature. Pipes here rusted, and this happens in iron pipes, this happens in man-made structures, it happens in non-man-made structures. The reason that the pipes rusted here is the same reason that the Grand Canyon in Arizona is red. It's as much an act of nature that caused that natural corrosion as the wind and the water that carved out that earth feature. Natural corrosion is any act of nature, as Dodge held, and it squarely qualifies as an act of nature in this particular policy. The last point I want to make, and I'd be remiss if I didn't, is how critically important this provision is in the state of Florida and the property insurance market. The amicus touches on this, but 40% of homes in Florida were constructed before 1975 with cast iron pipes. They estimate about 2.5 million.
That's not really though for our consideration. Ours is just the language of the, I mean, let me ask it this way. Is there something that we should be calculating and construing a policy where we take into account the policies or the implications of our interpretation beyond kind of our textual constraints of interpreting the policy as written?
Well, I certainly think that the court should consider the ramifications, like any appellate court, of its holding. Certainly confined to the record, but I can confine my argument to the record as well, if you'll allow me to make an extrapolation from it. So in our record, in our policy, if you look at it, the one piece of this issue raised in the amicus is it's going to be really hard to get insurance. Well, the other side of it in our record, if you look at our deck page, for example, my client collected no policy premium for this. You can see on the deck page that the inclusion of this endorsement created a credit. You can also see there's a letter attached to the complaint where my client said, if your home's older than 40 years, we don't give you full water damage coverage. Not what counsel's saying, we don't give you full water damage coverage during catastrophic events. We don't give you full water damage coverage, period. You can buy it back, which this insured did not, but it's not available. My client didn't charge a premium. Now, going back to Justice Lawson's decision in that Narachi case, he said, quoting a case from Texas, the insured's risk is, in a real sense, borne by the insurer's policyholders as a group, from whose pool of premiums all claims must be paid if the insurer is to remain in business. Now, I don't want to say that's prophetic, but I think everybody in this room knows what's happening in the property market. That's as far as I'll go, trying to keep it to the record. But I think those are certainly considerations that the court should take, and we've argued in our brief that claims for non-fortuitous losses, a pipe wearing out after 65 years, that depletes that pool of premiums. And we all pitch into that. We all hope we never have to use it, but it's there for fortuitous loss. It's not there for deferred maintenance. If the court were to allow those kinds of claims, if those kind of claims come in, then it encourages things like, why would I want to fix the pipe? Why would I do this? Let's just wait till it breaks, submit an insurance claim. And I will submit that in this state, under the law in this state, that's not the purpose of insurance. So what we would ask is that the court follow Dodge, particularly not only in the term in isolation, but given the contextual clues we've discussed, and affirm the decision on appeal.
Thank you, counsel. Mr. Nation?
Yes, thank you, counsel. I'll address, I've just made a few notes. They could have written the exclusion. What they're asking here is that it be interpreted broadly. It's undefined. They want it broadly. All they had to do is say, however caused, regardless of the cause, otherwise caused. And I cited several insurance policies that said that's how the exclusion applies. They didn't. And they chose to interpret it or write it this way. And there has to be a narrow interpretation. And if we've provided a reasonable interpretation, and they have, I don't believe they have, then it has to be interpreted in favor of the insured. As to accidental, they ignore the language of the policy. The policy says, we do not, that's kind of clunky, but that's where we're going to get our coverage. We do not insure, however, for loss caused by wear, tear, deterioration, corrosion, or any quality in property that causes it to destroy itself. It says it. If it ended there, we wouldn't be here. That's what caused the loss. It doesn't. It says if any of these cause water damage, not otherwise excluded, that's why we're here today, we cover the loss caused by the water and tear out. So their argument ignores that. It just has to be unexpected and unintended. They can make that argument to the jury if they want to. That's not part of the record in this case and wasn't decided in this case. As to the two cases that Dodge cited, one was a snowstorm, which is an act of nature, and the other was, it wasn't a definition. If you look at the opinion, the Coyle case, Connecticut case, it was not a definition of act of nature. The question was, there was a tree root that grew, and the question was the tree root an act of a human? Because there would be liability on the property owner if it was the act. if it was an act of a human, and they just threw out this sentence as, no, it's not an act of human, it's an act of nature. They didn't define it. They didn't cite any cases. They didn't look for a definition of it. And that's all they got. And so, let's see. The premium, yes, go ahead.
Are you familiar with the BBU? I don't know how to pronounce it. The Maine Supreme Court case that counsel's referenced and was cited. It seems to be pretty, although I think earth movement exclusion kind of the same language here. Do you think that was wrongly decided, or what's your assessment?
Yeah, earth movement is a different animal than what we have here, because earth movement, like a sinkhole, and we've got a fifth DCA case right on this issue, occurs over a long period of time. In geological time, 1,000 years is a blink of an eye. But there is a point when earth movement causes damage to a structure. There is a moment in time when earth movement causes that. Plus, and we can't get away from the situation we have here, which is the policy says we're going to cover water damage from a plumbing system if it was caused by wear, tear, deterioration, and corrosion. That is a very specific grant of coverage. And then they go into their exclusion, and this, I'm going to get to the premium argument here. They have an exclusion that lists 5 things. There's a modifier they included, and they're saying they're not getting the benefit of their bargain. Of course they are. That exclusion applies to lots of different losses, many, just not this one. And they know it doesn't because they granted coverage for it. And if they wanted to say so, they should have said, we don't cover however cause, regardless of the cause. And they chose not to. At a minimum, with everything we have, with the trial court orders across the state saying wear, tear, deterioration, and corrosion is not an act of nature. With the way the 4th DCA did their analysis and the definition they came up with, where they said just their, and I'll say, I don't mean any disrespect, but they're cobbled together, those 2 definitions, can be reasonably interpreted to define the everyday meaning. There's almost as many errors in that sentence as there are words. There is no everyday meaning of act of nature. The fact that they think that is a reasonable interpretation proves we have one. I mean, it pretty much proves there's more than one. They didn't say the, and they couldn't. And then the definition of itself, as the courts have said, post-Dodge doesn't make any sense. Again, I'll end where I started. I know it's a big ask, but it is unprecedented what the 4th has done here in the way they did it, rejecting Couch and rejecting Blacks. And in the same day, a different panel says, no, that's how you interpret phrases in an insurance policy. And so I appreciate the time. Thank you all.
Thank you both. Counsel, we stand adjourned.
Thank you. Bye-bye.